Hi all, welcome back to a new post today. And in today's post, we'll have a quick roundup of the polity and governance that made news last week. That's from April 23rd to April 30th. I hope you all are doing really wonderfully well, and let's have a quick review of what happened with regard to polity and governance from the GS paper 2 mains for the civil services examination point of view. So the whole week, if I would say, was dominated by important news of Karnataka Assembly elections, and apart from that, it was the same-sex debates that was going, same-sex marriage or the same-sex union marriage issue with the Supreme Court, the debates which were going on between the Supreme Court and the Government of India. Apart from that, we had the 50th anniversary of the landmark Kesavananda Bharati case that propounded the theory of the basic structure of the Constitution that limited the Parliament's amending power. We had the National Panchayati Day celebrated on April 24th, and the awards were given. National Panchayati Week was commemorated. Apart from that, we had the Supreme Court hearing the plea regarding the abolition of deciding to hear the plea regarding the abolition of the collegium system, with regard to which there is appointments to the Supreme Court and High Court. So the present system is the collegium system. There was a demand for the National Judicial Appointments Commission, and this was scrapped down in 2015. We had Supreme Court directing the government and the state governments as well, telling them to act against hate speech suo motu rather than actually waiting for a complaint. There was the restless plea at the Supreme Court. The Prime Minister's Cares Fund was in news because the opposition party were demanding that it should be audited, and Arunachal Pradesh hasn't been very happy with the land border agreement with Assam. Apart from that, we have the Maoist attack in Chhattisgarh, and let's see what is the government strategy. We had the Dimasa insurgent group having a tripartite agreement with the centre and the Assam government, and also we had the Solicitor General telling the Supreme Court that let the same-sex marriage issue be decided at the legislature and not the judiciary, while the Supreme Court told the LGBTQ communities who filed a petition that it can be a facilitator rather than getting into the notion of legalization of same-sex marriage. And the final one is about the Kashi Sangamam Aradhana, and apart from that, we have the Supreme Court telling the governors that now they should not sit on the bills and then instead send back the legislations as soon as possible. And the very first one is about the demand for a caste census. Now we know that in Karnataka there's assembly elections, the campaigning is going on, and there will be assembly elections very soon in Karnataka. This has led to voices coming up with regard to a caste census to happen. So we all know that we should all remember that the caste census with regard to SC and ST has always been enumerated with regard to every census, but not with regard to those castes which come into the OBC. Now there has been a growing demand that there should be the counting of the castes that come into the OBC, and for the very last time we had the enumeration of the castes coming into the OBCs was in 1931, and after that we did not have any census counting the castes that come within the OBCs. There was a socio-economic caste census that was carried out in 2011, but then the data was not published. And so it is on the basis of this 1931 caste-based census that the Mandal Commission report said that the OBCs constitute 52% of the population, and they were given 27% reservation. This socio-economic caste census, which was conducted in 2011, and studied the socio-economic backgrounds of both the rural and the urban households, and it was carried out by three organizations, that is the Department of Rural Development, Ministry under the Ministry of Rural Development and Panchayati Raj, and you had the Ministry of Housing and Urban Affairs, and also the Ministry of Home Affairs, which did the caste census under the Registrar General of India and the Census Commission of India. So does the Constitution speak about enumeration of caste census? No, it does not. But yes, we have Article 340, which says that there should be the appointment of a commission to investigate into the condition of the socio-economic backward classes. So the Constitution does not specify any way specifically OBCs, and instead calls them the socio-economic socioeconomic backward classes, and also it asks this commission to look into the difficulties under which they labor. The commission is assigned to make recommendations to the union and the states for removal of any such difficulties and to improve the situation of the socioeconomic backward classes. And if this has to be happen, we need to know the castes that come under the backward classes, and that is why there is a growing clamor for caste-based census, and also to know that which castes are actually left out from the reservation benefits and which castes are taking all the benefits, or whether it's lopsided. However, there are debates and criticisms both for and against the caste census. Now, the Supreme Court dismissed a plea recently also regarding the challenging of the Bihar caste census. So many states have started to undertake a caste census on their own, and we have one of them is Bihar and the other is Karnataka. The government was planning a decennial census in 2021, which is still pending, but which did not happen because of the COVID situation, and we still have the data only of 2011 census in the country. Now, there is a demand that the caste census should be included in the decennial census of 2021, but the government has said it cannot happen because the census is already halfway done. There is also a demand to make the data with regard to the socioeconomic caste census which was happened in 2011 during the UPA rule public, but that hasn't been done as well. And the most important next news is the landmark case which laid the boundaries to the parliamentary powers to amend the constitution by addition, variation or repeal. None other than the famous Kesavananda Bharati case that happened in 1973, and this April to the 24th April 2023 we went on to celebrate the 50th year of this case which laid the landmark doctrine of the basic structure of the constitution, which put a limit on the parliament's power to amend the constitution. Now, who is Kesavananda Bharati and what the issue is all about? Now, Kesavananda Bharati is a seer from Kerala. He is the man who actually saved the constitution through a simple act of approaching the Supreme Court in an attempt to save his mutt. So the Kesavananda Bharati case is versus state of Kerala, which happened in 1973, is also called as the Kesavananda Bharati judgment, and it is the landmark judgment of the Supreme Court. Let me tell you, it had 13 judges, and it is the largest constituted constitutional bench so far. The largest bench delivered its judgment in a 6-4 view of the judges. The judgment delivered in 1973 laid down that the Parliament can amend any part of the constitution unless it does not touch the basic structure of the constitution. Now, this Kesavananda Bharati, this man who's a seer, he challenged the Land Reforms Act in 1969, which were brought about by the Kerala government by C. Achyutha Menon, which had affected his mutt. And let me tell you that we had at that time the right to property. The right to property was deleted only by the 44th Amendment Act of 1978. Now, these land reforms, which were bought in 1968, took away a large chunk of the Ednir Mutt's property, which was headed by Kesavananda Bharati, the seer, and this causing it a lot of financial difficulties. Bharati therefore filed a petition in Supreme Court challenging the land reforms along with his lawyer Nani Palkiwala. Kesavananda Bharati argued that the new laws which were brought by the Kerala government actually violated his fundamental rights, specifically the right to religion under Article 25, the right to religious denomination under Article 26, and the right to property, which was still existing as a part of the fundamental rights until 1978 under Article 31. Alongside Kesavananda Bharati, representatives of the case included other companies as well, like coal, sugar and other industries which were actually adversely affected by the land reforms, also knocked the doors of the Supreme Court with the petitions of their own. In this case, now let me tell you, it went on for 3 long years before the top court, the 13-judge constitution bench, constituted the largest so far in history, heard the case for 68 working days. Now, since the Constitution of India came into 50, we had the right to property protected under Article 31 and 19(1)(f), let me tell you. But this right to property was deleted by the 44th Amendment Act of 1978 and included in part, and it was included as a constitutional right under Article 300A in the part 12 of the Constitution. So the bench went on to say that the Parliament can amend any part of the Constitution, but it should not touch the basic structure, and that basic structure cannot be altered by the Parliament. Now, it also laid down what are the features of basic structure. However, there is no absolute list till now which constitutes basic structure, and the Constitution also does not specify or define what actually is basic structure. But then the Supreme Court went to say on some words regarding that, and the Supreme Court in that very bench laid out supremacy of the Constitution, rule of law, federal character of the Indian Constitution, separation of powers between the legislature, executive and the judiciary, and the protection of fundamental rights as some of the features that is constitute the basic structure of the Constitution. It said that the basic structure doctrine is a common law legal doctrine of the Constitution of a sovereign state that has certain characteristics that cannot be erased by its legislature. Simply put, the doctrine actually establishes that the Constitution has a basic structure that cannot be altered by the Parliament through amendments. It is through this basic structure doctrine that the Supreme Court of India derives its powers to review and also strike down constitutional amendments and acts enacted by the Parliament that come into conflict with the Constitution and also the basic structure of the Constitution. Many a times since the 1973 judgment of the Kesavananda Bharati case, there are many cases that upheld the basic structure of the Constitution, and one such case is the National Judicial Accountability Appointments Commission, which was going to replace the collegium system, and it was scrapped down in 2015, saying that independent judiciary is a major feature of the basic structure of the Constitution and it cannot be altered by an amendment, which was the 99th Amendment Act of the Indian Constitution of the Parliament. So this is a very, very famous case which actually protected the sanctity of the Indian Constitution. And moving on is another most important thing which we celebrated, and that is about the Panchayati Raj Day. So it is celebrated on 24th April every year to commemorate the historical day when the 74th Amendment Act of the Constitution came into force in 1993. Now this day celebrates national local self-governance and also democratic decentralization. The Ministry of Panchayati Raj is the nodal ministry which works on empowerment and accountability and development of Panchayati Raj institutions to ensure inclusive development, social justice and efficient delivery of services. Now, Constitution recognized Panchayat as institutions of self-government. It was only after the 73rd Amendment Act that constitutionalization of the local self-governments happened. Before that, they were not constitutional bodies. It added certain schedules and parts as well. So, Schedule 11 and 12 and Part 9 and 9A was added to the Constitution. Now, there are 2.51 lakh Panchayat in our country, almost 2.39 lakh Gram Panchayat, 6,904 Block Panchayat and 589 District Panchayats in the country. There are more than 29 lakh Panchayati representatives, and recently the 15th Finance Commission has also catered to local government grants both for the rural and the local panchayats or the local bodies. There was a National Panchayati Awards that were given out, and the classification of the award is the Deen Dayal Upadhyay Panchayat Shashastikaran Puraskar, which was given for the best performing panchayat. The Nanaji Deshmukh Rashtriya Gaurav Gram Panchayat Puraskar was given to the Gram Panchayats. Gram Panchayat Development Plan Award was given to the Gram Panchayat and the Village Council. And apart from that, you had the Child Friendly Gram Panchayati Award. So these awards were given out by the President of India. The most important next one is regarding the Supreme Court itself, and it is going to hear a plea to abolish the collegium system. Now, the Supreme Court has said that it is willing to hear a petition seeking the abolition of the collegium system of judicial appointments. Let me tell you that the collegium system of judicial appointments is not a constitutional mechanism. It came about in 1993 through the 3 judges cases, and it is used by the Supreme Court to decide on the names that have to be forwarded so that the President of India appoints the judges of the High Court and the Supreme Court. Now the collegium system was the government wants the collegium system to be scrapped because it is tied under anonymity and also secrecy. So we really do not know how the judges and what is the credibility or what are the criteria that they use to select the judges to the appointments to the highest courts of the country, and that is the Supreme Court and the High Court. Now the petition sought the revival of the National Judicial Appointments Commission or the NJAC, which came into being after the 99th Amendment of the Constitution. And this was to replace the collegium system of appointment. It was to bring the participation of the executive also in deciding the names of the judges. However, it was struck down in 2015. The petition was filed amidst the verbal attacks by the Law Minister Kiren Rijiju on the collegium system, calling it opaque or secrecy based and non-transparent. The petitioners called the collegium system a synonym for favoritism and nepotism, where nobody knows on what basis the judges are actually selected and the names are actually taken out for appointment to the judges of the High Court and the Supreme Court. It has sent repeated representatives to the centre to evolve a mechanism alternative to the collegium system, and this NJAC was brought about. So the collegium system was brought about in 1993 and the NJAC was brought by the 99 Constitutional Amendment Act. Let me just tell you that the National Judicial Appointments Commission would consist of the Chief Justice of India, 2 senior most judges of the Supreme Court, the Law Minister, and 2 eminent persons that are nominated by the centre. And the collegium system consisted only of the Chief Justice of India and the 4 most senior most judges. So the collegium system is completely of the judiciary, while the National Judicial Appointments Commission is a combination of both the judiciary and the executive, therefore executive taking part. However, this was scrapped down and struck down by the Supreme Court in 2015, saying that it interferes with the independence of the judiciary and therefore it reverted back to the collegium system. Now, this is about the collegium system and how the Supreme Court CJI also expressed a doubt whether the collegium system could actually be challenged under Article 32 of the Constitution. So we need to see when the Supreme Court really hears the plea about the collegium and what will it be, what will the arguments that the judiciary give for this and what arguments will the government forward for this. So it's really going to be interesting about that. And the next most important news is that the Supreme Court now has asked the centre and the states to act against hate speech in India anywhere and take suo motu cognizance of the offence and not wait for complaints. Now, the Supreme Court has extended the scope of its order and directed Uttar Pradesh, Delhi and the Uttarakhand police also to take suo motu action against hate speech cases, and directed all the states and the union territories to register the cases wherever hate speech occurs, even if there is no complaint. So on their own, the court warned that delay in filing of the cases will be treated as contempt of court, and terming the serious offence a very serious offence. The judiciary or the Supreme Court went on to say that hate speech is capable of affecting the secular fabric in the country. The petitioners recommended a nodal officer to be appointed in each state, to which the bench suggested 1 nodal officer for every district. The petitioners said that the procedure needs to be set out for the take down of hate speech, especially from social media platforms. It said that the court has been entertaining petitions against the hate speech in different parts of the country for larger public good and to ensure the establishment of rule of law. Let me, however, remind you that hate speech is nowhere defined and we do not have a particular law to deal with hate speech, and there comes the problem. However, there are primary laws to deal with the hate speech which are used from the IPC. So we have section 295A and section 153A along with 153B, which is used to deal with hate speeches. These definitely do not deal with hate speeches specifically. Now, the state invokes section 295A along with 153A, which penalizes promoting enmity between different groups on the ground of religion, race, place of birth, residence, language, doing acts that are prejudiced to the maintenance of harmony in the society, and also section 505 of the IPC that punishes statements conducting public mischief. Now, 153 punishes words, or 153B punishes words or actions that causes hatred towards a community and imply that they should be deprived of their rights or as Indian citizens. 295A relates to outrageous feelings or religious feelings against any class. Apart from these sections, there is section 66A of the Information Technology Act that punishes sending offensive messages through communication services, and it is added when speech is online. So this deals with the social media or or the digital media part of the hate speech. Now, the origins of the 295A was brought in 1925, that is during the British era. Now, even the Law Commission report of 267 said that the general provisions in the law, the courts are not able to successfully prosecute the hate speech brought before them because there is no specific law defining what is hate speech. There is no particular law also punishing for hate speech, and therefore it recommended adding new provisions in the law to deal with speech that incites hatred, causes fear and alarm on the grounds of religious or community feelings. While a new law is taken to be a step very forward, there are doubts how far this can actually lead to the situation, because every new law that is made, there are some backdrops as well, and also sometimes misuse because of the vague definition of such hate speech areas. So this is about hate speech and how the Supreme Court is going. We do not have a particular law. How the Law Commission has said that we need to do, we have specific provisions with regard to hate speech to tackle them, which actually affects the secular fabric of the nation, and especially fraternity and brotherhood. Now, malaria, on the health side, we have malaria is now being treated as a notifiable disease. So previously it was a notifiable disease only in few states and union territories, and now it's going to be a notifiable disease all over the country. Now, a notifiable disease, that's for better tracking of malaria and also to totally eliminate the disease from the country by 2030 and to make India malaria free by 2027. And this is the vision of the government. Now, a notifiable disease is any disease that is required by the law to be reported to the government authorities. So the states or the local governments have to report the cases to the center, and this collection of information allows the authorities, that is the health authorities, to monitor the disease, provide early warning of the possible outbreaks. Now, even the WHO rules also say that it requires the disease reporting to the WHO in order to help with its global surveillance and also advisory role. Making a disease legally notifiable by the doctors and health professionals allows for intervention to control the spread of the highly infectious diseases. Now, registered medical practitioners need to notify such diseases in a proper form within 3 days and notify verbally via phone within 24 hours depending upon the urgency of the situation. This means that every government hospital, private hospital, laboratories, clinics will have to report the cases of the disease to the government. Currently, malaria is a notifiable disease only in 33 states and union territories. With this, this will also include Bihar, Andaman and Nicobar Islands and also Meghalaya to make it a notifiable disease. The Health Ministry is also working with a joint plan action along with the Ministry of Tribal Affairs for malaria elimination in tribal areas. Let me tell you that we also have a data monitoring system through an integrated health information platform, which is called as HIP Malaria Portal, and there is periodic regional review meetings to keep a check on the malaria growth as well. Malaria is a life-threatening disease caused by parasites Plasmodium vivax, Plasmodium falciparum, Plasmodium malaria and Plasmodium ovale that are transmitted through the bite of the infected female mosquitoes. Now, some of the notifiable disease which are notifiable on the same basis like malaria are AIDS, dengue fever, almost 22 diseases. We have hepatitis B, malaria, which is now included whooping cough or pertussis, rabies, tetanus, viral encephalitis, anemia, chickenpox, diphtheria, influenza, etc. So these are the notifiable diseases and a very big step to tackle and to eliminate malaria from the country. Now, a defamation case has been filed against Rahul Gandhi for his words against the Modi surname, and now he has filed his appeal in the Gujarat High Court. So he was convicted by the Metropolitan Magistrates Court in Surat in March 23rd under the IPC sections 499 and 500, that is for criminal defamation. Following the verdict, Rahul Gandhi who was elected to the Lok Sabha from Wayanad in Kerala in 2019 was disqualified as an MP under Article 102 Clause 1 under the provisions of the Representative People's Act 1951 because he has got a sentence of 2 years or more, which is the maximum sentence that is given in a criminal defamation case, and now he is going to appeal to High Court. The next appeal will be in the Supreme Court. The Supreme Court now is hearing the wrestlers' plea, and we have our Olympic medals really in problem. So the Supreme Court will hear the plea of the protesting wrestlers on sexual harassment allegations against the WFI chief Brij Bhushan Singh. So the Supreme Court noted that there are serious allegations that are contained in the petition by the wrestlers who have represented India at the top, and also issued a notice to the Delhi police to file a FIR. The wrestlers have also demanded that the centre make the public the findings of the five-member oversight committee that investigated the allegations of the WFI chief. Now, the Common Commission for Women said that it received a complaint from the women wrestlers alleging that they had given a written complaint to the police 2 days back, but no FIR has been registered until now. The former Indian athlete and Indian Olympic Association PT Usha criticized the protesters by protest by the wrestlers and said that instead of going to the streets, they should have actually come to the Indian Olympic Association. And however, they also criticized for not keeping for not hearing the petition or the grievance of the wrestlers. So the most next important one is about the PM's Care Fund. Now, it is a fund which is a public charitable trust. Now, it has come under criticism, saying that questioning why it is not audited, so and shrouded in secrecy. So the PM's Care Fund is a public charitable trust. It has been kept. It has been set up keeping in mind the need for having a dedicated fund with primary objective of dealing with any kind of emergency or distress situation like the post-COVID-19 pandemic, and also to provide relief to the affected people. The Prime Minister is the chairperson of the PM Cares Fund. The Minister of Defence, Home Affairs, Finance, Government of India are the ex officio trustees of this fund. The PM Cares Fund has been registered as a public charitable trust. The trust deed of PM Cares Fund has been registered under the Registrations Act of 1908 at New Delhi, and it came into being in 2020. Now, the most important federal issue that has been in news is about the Arunachal Pradesh Assam deal. So, Arunachal Pradesh isn't happy. There was the Assam Chief Minister Himanta Biswa Sarma and Arunachal Pradesh Pema Khandu had signed an MOU over the long-standing border dispute between the two states. A development of the Home Minister Amit Shah called as historic. Now, let me tell you that the Parliament has the authority to modify the borders between the states. The two states have a 800-kilometer long border, and the disputed areas, the MOU deals, which are 123 border villages and span 12 districts of Arunachal Pradesh and 8 districts of Assam. So we know that Arunachal Pradesh was previously called as Northeastern Frontier Agency, and it was carved out of Assam in 1954. It became independent, however, later in 1972. Now, when it was the Northeastern Frontier Agency, a subcommittee headed by the former Assam Chief Minister Gopinath Bardoloi had made a set of recommendations with regard to administration of this frontier agency and submitted a report in 1951. In line with the recommendations of this report, a 3,648 kilometer of the plain area of Balipara and Sadia foothills were transferred from the Northeast Frontier Agency, that is the now Arunachal Pradesh, to Assam, Darang and the Lakhimpur districts. Now, when Arunachal became a union territory in 1972, it contended that several of these areas in the plains that had traditionally belonged to the tribal chiefs and the communities were transferred to Assam, and it criticized this action. Now, the dispute over 37 of these 123 villages has been resolved in 2022 itself by the signing of the Namsai declaration between both the CMs. This effectively reduced the number of disputes to 86. Now, through the MOU, the disputes of 34 villages now has been amicably resolved. The village boundaries of the 49 remaining villages are unresolved, and the MOU states that these will be decided by the regional committees, who will finalize the boundaries within a period of 6 months. So how actually are the interstate boundary issues addressed in India? We have a lot of interstate boundary issues recently even coming up between Maharashtra and Kerala. Odisha itself has boundary disputes not only with West Bengal, Andhra Pradesh, Chhattisgarh, but also Jharkhand itself. Then there are disputes between even Gujarat and Rajasthan also. So attempts are made to resolve mostly the interstate disputes through cooperation by both the sides, where the centre intervenes as a facilitator or a neutral mediator, and if the issues are resolved amicably, the Parliament can also bring out a law to alter the interstate boundaries, as it did in the case of Bihar Uttar Pradesh Alteration of Boundaries Act in 1968, and also the Haryana Uttar Pradesh Alteration of Boundaries Act in 1979. In the Belagavi issue, the Home Minister met the Chief Minister ministers of Maharashtra and Karnataka and asked them to form a 6-member team comprising 3 ministers from each side to resolve all the boundary issues. What are the other avenues or the methods available? So constitutional methods are judicial redressal. So the Supreme Court as original jurisdiction with regard to deciding disputes between the center and the states or between the states under Article 131. Apart from that, we have the formation of an interstate council under Article 263 of the Constitution, which gives the powers to the president to form an interstate council for resolution of any disputes between the state. The council is a forum for discussion between the states and the center. In 1988, let me tell you, the Sarkaria Commission suggested the council should exist as a permanent body, and in 1990 it came into existence through the presidential order. So this is the federal issue between Assam and Arunachal Pradesh. Now the next one, biggest one, is about the Maoist problem. So after 2 years, we had a dastardly attack on the security forces in Dantewada, and the latest attack is the biggest strike by Naxal security forces in the state in 2 years. 10 district reserve guards personnel and a driver were killed when the extremists blew up the vehicle in the Aranpur area of Dantewada district. The explosive created a 10 feet deep crater, splitting the road and completely destroying the vehicle. The geographical tri-junction of the states of Chhattisgarh, Telangana and Odisha, located right in the southern tip of Sukma district in the South Bastar region, is an area which actually and usually witnesses maximum number of such incidents, including the deadly 2010 Maoist ambush in Dantewada, where 75 CRPF and 1 Chhattisgarh police personnel was died. So how is the center actually dealing with these Naxal problems or Maoism? There is an operation, security operation doctrine that was launched recently, and it is called as Samadhan. So what does Samadhan actually mean? It's a new strategy of the government of India. The Samadhan was launched by the Ministry of Home Affairs as an answer to deal with the Naxal problem, and the acronym Samadhan stands for Smart Leadership, Aggressive Strategy, Motivation Training, Actionable Intelligence, Dashboard based key performing indicators, key result areas, harnessing technology, action plan for each theatre, and no access to financing. The Ministry of Home Affairs has suggested the use of trackers for weapons and biometrics in smart guns. A unique identification number will be given for gelatin sticks and also explosives. At least 1 unmanned aerial vehicle or drones or mini drones for each CRPF personnel battalions deployed in the Maoist hotbed. Helicopter support to the operations in these areas. Helicopters are to be used to rush supplies and reinforcement, and also increase the number of flying hours. Joint task forces for operating along the interstate boundaries to be set up. Better interstate coordination. 445 police stations to be set up in the Naxal belt. Resumption of left-wing extremism specific schemes. Prevention of money laundering to be reviewed. Fast tracking of building infrastructure with regard to solar powered lights, mobile towers, 3G connectivity and railroad connectivity. Indian Army specialized forces such as Greyhounds to be trained continuously, and forces to be more proactive and also aggressive. So this is about the Naxal Samadhan program, which is being adopted by the government now. So One Earth, One Health Advantage Healthcare India 2023. Now we all know this is the 6th edition of One Earth, One Health Advantage Healthcare India 2023, and India's goal is to make healthcare accessible, affordable, not only for the citizens but also for the whole world, and this was said by the Prime Minister. So this is the policy focus of the health sector. Let me tell you, Sustainable Development Goals 3 deals with ensuring healthy lives and promoting well-being for all at all ages. India has a traditional healthcare system which not only focuses on good health or free of diseases, but also is an answer to stress and various lifestyle diseases as well. Now, the Ministry of Health and Family Welfare, in association with the Federation of Indian Chambers and Commerce and Industry, has co-branded the 6th edition of One Earth, One Health Advantage Healthcare India 2023 with India's ongoing G20 presidency. The Dimasa insurgent group, another news that is from the northeast. So an Assam-based insurgent group that is demanding for a Dimasa land in Assam assigned a tripartite MOU with the center, the Assam government, and with itself, that is the Dimasa National Liberation Army. Now these will give up all the violence, surrender all the arms and also ammunition, disband their armed organization, vacate all the camps of the cadres and join the mainstream. The ministry said that this will bring a complete end to insurgency in the Dima Hasao district. Apart from that, there will be a Dimasa Welfare Council that will be set up by the government of Assam to protect, preserve and promote social, cultural, linguistic identity to meet the political, economic, educational aspirations of the Dimasa people. The MOU provides for appointment of a commission under the 6th schedule of the constitution to examine the demand for inclusion of additional villages contiguous to the North Kachar Hills Autonomous Council. It also provides for necessary measures taken by the central government and the government of Assam to rehabilitate those who have surrendered the arms, that is the cadre people of the DNLA, and also a special development package of 500 crore each will be provided by the Government of India, Government of Assam for a 5-year period for all-round development of the North Kachar Autonomous Council as well as the Dimasa people residing in other parts of the state. Now, the second last important news is about same-sex marriage or same-sex union. Solicitor General stated very openly to the Supreme Court that marriage now should be debated in the Parliament. The Solicitor General of India said that legal recognition of same-sex marriage by the Special Marriage Act, which is and making it gender neutral, should ideally be debated in the Parliament and not the court. A debate in the Parliament will be assisted by national views of the experts, views on impact, effect and also the implication of it on several laws. It said that there are at least 160 provisions which cannot be reconciled with a small change in the Special Marriage Act of making it gender neutral to legally recognize same-sex marriage. The centre made it very clear that the Transgender Persons Act of 2019 was the Parliament's response to decriminalization of homosexuality by the Supreme Court in 2018, and the term transgender person in the statute is widely defined to include all spectrums of the LGBTQIA+ community. Supreme Court now took a very big step back and it said it can be a facilitator of the rights of the same-sex couples. Now, the Supreme Court has been receiving petitions, we know, to legalize the same-sex marriage, and the Supreme Court is which looked to legalize the issue under the Special Marriage Act, now has said that it cannot do so and it will be a facilitator. It said it is conscious of the limits of the judiciary, and this was said by our own Chief Justice of India, D.Y. Chandrachud, after the Solicitor General argued that recognition of the same-sex marriage is not a fundamental right. So therefore, the Supreme Court now told them that it is going to be a facilitator to push the government to ease concerns of the same-sex marriage. Supreme Court said it will play the role of a facilitator and ask the government to take and do all what it is needed to remove the barriers and ease the day-to-day living of the humans who are cohabiting or as same-sex partners in areas like joint banking, insurance, admission of children into the schools, without touching upon the issue of legalization of same-sex marriage under Special Marriage Act. Now, the 7th day of the court witnessed a sharp diversion on the constitutional bench headed by our Chief Justice of India. The petitioners have sought judicial declaration nothing less than full marriage, while the Supreme Court has said that it will be a facilitator and recognize their contracts. The turning point came when the government said that the court would encroach on the legislative arena if it gives a legal status to the same-sex marriage, and it would create a chaos considering the fact that many other statutes, including the personal laws, were designed solely for heterosexual marriage and not homosexual marriage. The court at one point also said that it suggested labels like semantics like contract, partnership instead of marriage. The court said, unlike the intervention to frame the guidelines under the Vishaka guidelines against sexual harassment at workplace, the case of same-sex marriage was not the same thing as the sexual harassment at a workplace, and there are many more linkages in every other statute as well. Now, the new turn in the court hearing began when the Tushar Mehta said that right to love, right to cohabit, right to choose one's partner, project one's sexual orientation were fundamental rights, but no fundamental right is there that seeks recognition of marriage, or there is no fundamental right to marriage between same-sex relationship. The centre, through the Solicitor General, said petitioners cannot ask the state to take an affirmative step towards recognition of same-sex marriage. And before ending, it's the Kashi Telugu Sangamam Ganga Pushkaral Aradhana that was inaugurated and addressed by Prime Minister Narendra Modi in Varanasi through video conferencing. Now recently, the Kashi Tamil Sangamam and Saurashtra Tamil Sangamam were also organized. The Ganga Pushkaralu commenced on 22nd of April and will go on to 3rd of May in Varanasi. In the 12-day event, a large number of pilgrims from Andhra Pradesh, Telangana are visiting Kashi to offer prayers to their ancestors, and this festival is celebrated every 12 years. This is the second event of the recent past to be organized in Varanasi after the Kashi Tamil Sangamam. The centuries-old between Kashi and Telugu people is a reflection of the Ek Bharat Shresth Bharat. The festival is celebrated once in every 12 years, where pilgrims from Andhra Pradesh and Telangana visit Kashi to pray to their ancestors. Over 1.5 pilgrims from Andhra Pradesh and Telangana are expected to visit Kashi in the 12-day event. And Supreme Court has finally said that the governors do not have the power to sit on the bills and they must send back the bill as soon as possible, as mentioned in Article 201 Clause 1, which says that the government should not delay over the bills, send them for assent after they have been passed by the legislative assemblies, and this will lead to impasse, or this will actually stop the functioning of the legislatures, and also it will lead to non-functioning of the legislative assemblies. So this is what the Supreme Court said. Let me tell you that it is under Article 201 that the governor has the power to give assent to the bills, which after that they become law, and he has a power to give his assent, withhold his assent, or reserve the bills for reservation for consideration of the president. And this is all for your weekly roundup of your polity and governance current affairs for the week gone by from April 20th to 30th. And please don't forget to like, share, subscribe, and I shall see you in the next post. Happy learning.